Tiffany.
Right down the side. That sun is for real.
Yeah.
I'm gonna move. If I move up to the side. Yeah, yeah. Sorry, the sun is right in my eyes. So I'm gonna scoot over here. Serious. I can see it. I can see it.
Am I in your way?
Yes. You take that out. As long as it doesn't hurt our eyes. She's okay.
Don't want the glasses on or off?
You keep them on.
Okay. Slide that to there.
Excuse me.
Everybody ready? Good afternoon. I'm Attorney Demario Solomon Simmons, along with my team. I have the great pleasure and honor of representing our survivors. We have two known living survivors with us still at this moment in the entire Greenwood community that we represent in this particular litigation. I have here sitting right next to me, our oldest living survivor, Mother Viola Ford Fletcher, who's here looking dapper as always. I have the two of the daughters, Hugh Van Ellis, Uncle Red, who we lost last month. His daughter, Lee Kraft here, and Mario Watson, of Uncle Mother Fletcher's grandson, Ike Howard. I have to my right, Dr. Tiffany Crutcher, Terrence Crutcher Foundation, also a descendant of her great grandmother, Rebecca Brown Crutcher, was a victim of the massacre, barely escaped with her life. And my associate Kimberly Hettenkemper, one of the outstanding lawyers on this team. We have an unbelievable team of lawyers around this country. Also have Jana Knott here in Oklahoma City, our appellate counsel, and Randall Adams is right behind me. He's representing Shorty Walton Zabel, who has been an outstanding co-counsel with us throughout this litigation. And we have Bria Nelson, that's here from Human Rights Watch, who's been also a partner with us on this work, this journey, really over the last 5 years. On September 1, 2020, we filed this particular lawsuit utilizing the public nuisance statute that has been in Oklahoma since 1910. We filed this lawsuit because the massacre created a nuisance that's continued to this very day. A nuisance that was created, as the Supreme Court has stated in Johnson versus Johnson. A nuisance occurred because crimes occurred during the massacre. Crimes of murder, crimes of kidnapping, crimes of arson, crimes of burglary, robbery, assault. And I can continue to list those crimes. And those crimes made property uninhabitable and or destroyed property. Property like the Stratford Hotel, the largest African-American owned hotel in the nation at the time. Burnt down to the ground, never to be rebuilt. Right today, where the Stratford Hotel stood, it is vacant ground, vacant land. The Stratford Hotel was a place of employment, a place of pride, a place of employment, tax revenue, and a great place of housing. This is just an example of the continuation of the nuisance. And so what we filed today is the final brief in this case. As many of you know, our case was dismissed by Judge Wall on July 7, 2023, after she had stated earlier in 2022 that we can move forward. She dismissed our case. She did not give us any rationale until 5 days later. She stated that she dismissed our case because we didn't plead a proper remedy. First of all, we did. But more importantly than that, we didn't have to. Because as Randall and Jana will talk about more specifically, specifics of it, since 1984, plaintiffs like Mother Fletcher here in Oklahoma did not have to provide every detailed remedy that she needed in her case. So before I let you hear from my co-counsel, I had a reporter ask me earlier, is this a Hail Mary? And I said, no, it's not a Hail Mary. We're not desperate. And the reason I said that, yes, this is the last brief before the Supreme Court will decide this case. But we're not looking for a miracle. We're just looking for them to apply the law as written. We're not looking for a jump ball. We just want them to read the facts in the black letter law within this document. And they don't have to do anything special. They don't have to make new law. They don't have to stretch the law. They just need to apply the law as written. And if they do that, Mother Fletcher and Mother Randall and Mr. Hughes Van Ellis's estate will have our day in court where we can prove that this nuisance is still ongoing. And we can show, based upon the experts we're going to bring from around this nation, to state what it would take to fix or abate the ongoing nuisance. So with that, I ask my co-counsel, Randall Adams, from Shorty Walters Zabel, to give a little more insight.
Sure. So on August 3rd, 2022, Judge Wall ruled that Mother Fletcher, Uncle Red, and Mother Randall had stated a public nuisance claim. The way this works is that in a complaint, you just have to state a legally cognizable claim. Then you get a trial, and if you prove your facts at trial, then the court and you can come up with a remedy. But what Judge Wall said was, actually, the remedy you've suggested in your complaint, it doesn't work. So I'm going to just dismiss this whole case. I'm not going to give you a chance to go to trial at all. I'm not going to give you discovery. I'm going to say that this case dies now before anything has actually happened beyond briefing the complaint. And that's just not how the law works. And the evidence of that is we submitted our appeal and we argued why this didn't work. And the defendants put in 4 briefs opposing our appeal. None of them will actually defend that ruling. None of them will actually explain to the court, to the Supreme Court, why plaintiffs need to state the entirety of their remedy in the complaint. Instead, they came up with alternative reasons for why the case should have been dismissed. But those weren't the reasons why the district court dismissed us. And that's not going to carry the day here. The fundamental point is we should be able to proceed under the law. If you actually apply the law to the facts, we've absolutely stated a public nuisance claim. The court has already found that. We should get to go to trial, and we should get a chance to actually prove the case, just like any other plaintiff in Oklahoma gets.
Before you hear from Jana, I just want to underscore what I said earlier, that we lost Mr. Hughes Van Ellis, and we were all together last weekend in Denver, Colorado at his funeral. And while his daughters and his family, his sister, his nephew are still mourning his loss, they're here, standing here in front of all of you today to show you how important this was to Uncle Red. A man who was bombed twice as a baby in 1921 and then bombed as a World War II veteran in a specific field, who went through Jim Crow, who went through discrimination decade after decade, right here in this city, in Oklahoma City, working at Tinker Air Force Base. A man who had to go back to high school as a grown man with a family to get his high school diploma from Douglas High School in 1951. I'm saying all that because to say this. Despite all that he went through, despite all Mother Fletcher's gone through, despite all Mother Randall's gone through, they still believe in the fundamental principle of justice here in America. And as Uncle Red would say, we are one. And to show and prove that we are one, they should receive the same justice that everyone else in Oklahoma receives. And to talk more about the specifics and the procedure of what we're looking for from this day forward with the Supreme Court, I asked Jana Knott, our co-counsel and our appellate counsel, to give a little more explanation on that point.
Thank you, DeMario. So just to give you all a little bit of context on the brief that was filed today, This case was appealed after, as Demario mentioned, Judge Wall dismissed the case on motions to dismiss from all of the defendants. So under the Supreme Court's rules, that dismissal order was subject to the court's accelerated appeal procedure. And so typically under that accelerated appeal procedure, the parties are not allowed to file any additional briefs unless specifically ordered to do so by the court. On September 20th, the court did order the parties to file briefs in this case. And so on October the 10th, we filed the first brief in this case, our brief in chief. And on October the 25th, all four of the defendants filed answer briefs in the case. And so the brief that we filed today is the reply to those four answer briefs. And so after today's filing, the briefing cycle is completed based on what the court ordered. And so the case stands ready for a decision from the court, of course, pending any other orders that the court may enter in the case.
Thank you, Jenna. I want to acknowledge Elise Miller here from the University of Oklahoma Law School. She's the president of the Black Law Student Association, and we're excited to have a young aspiring lawyer standing for justice, witnessing history. And that's what this case is about. It's about us all standing for justice and making sure, as we stand here at the Oklahoma Judicial Center, that our Supreme Court can do what's right. I want to make one thing clear. There's nowhere else for us to go. There is no going to the United States Supreme Court. There's no going to the federal court system. This is it. It's been 102 years since Greenwood was bombed from the sky, since houses were burnt down to the ground, since 10,000 to 12,000 people remained homeless overnight, 1,000 to 3,000 people disappeared, over $200 million in property damage. 102 years. We have two survivors left. One is here. This court that I stand in front of, we stand in front of, has the opportunity to do what's right for the first time in 102 years. Give us the opportunity to get into court. Let us prove our case. That's all we're asking for. Thank you. I'll take a few questions. Specifically, our brief is saying that Judge Wall was incorrect, and the Supreme Court should send us back to her courtroom and allow us to move this case forward in discovery toward the trial.
How would you describe the sense of urgency to get this done?
It's hard to put the urgency in words, particularly when I'm standing here right next to Uncle Red's family. He's not here. I have not done one of these press conferences in 2.5 years, and he's not right here. So as we told the court, we've been saying time is of the essence. There's no greater example of that than my partner, Uncle Red, not being here while I'm talking to you today.
Do you have any idea when the court will issue a ruling on your brief?
We have no idea. We hope it's very, very soon. Mother Randall's birthday is Friday, November 10th. She'll be 109 years old. Wouldn't it be wonderful if the court gave her the greatest birthday gift she's had so far, ruling on this case this week and allowing us to move forward? I know that's what she wants more than anything for her 109th birthday.
You touched on this already, but that the interim hearing last month at the state capitol, several people in the room stated that they felt like it was intentional that the state was dragging its feet. Is that still an accurate statement?
I think the evidence speaks for itself. That was always their intention to drag this out as long as possible. I mean, you know, when we started, Mother Fletcher was 106, Mother Randall was 105, the Red was 100. You know, they just playing the math. So there's no way these people can still be here. But we're still here. And even though Uncle Red's not physically with us, his estate is still with us. And we're going to continue to push this issue until we get justice. That's good. And thank you. Right. That's strong for you guys. Such a long story about the young lady. I felt like I knew him my whole life.